Picture this scenario. You walk into your local sheriff's office with a clean background, proper training, and a track record of responsible behavior. You're following every rule. Then an official looks you straight in the eye and says, "Sorry, you don't qualify enough." There's no crime on your record, no threat you pose. It comes down entirely to their personal judgment about whether you deserve your rights. For years, this was reality in states like New York and California. Gun owners had to beg for permission, not because of anything they'd done wrong, but because the system was designed to work against them. Everything changed with a landmark 6-3 Supreme Court decision that pulled the plug on that broken system. This wasn't just a legal update. It was a constitutional course correction. If you carry or ever plan to, you need to understand what this ruling unlocked and how it tore down the old rules. The Bruen decision marked a victory, but it won't enforce itself. Rights only have meaning if we know them, use them, and defend them. Gun owners now play a critical role in determining how far this ruling reaches. This means tracking new local laws and speaking out at city council meetings. It means supporting litigation that challenges unconstitutional measures. And yes, it means continuing to carry responsibly, confidently, and within the law. This ruling opened the door, but it's up to us to walk through it and keep it open for the next generation. We can't just celebrate a win, we need to turn it into a lasting movement. The case was New York State Rifle and Pistol Association versus Bruen, a challenge to New York's long-standing concealed carry law. For over a century, New York required applicants to show proper cause to carry a concealed firearm in public. Here's the problem: self-defense wasn't considered good enough. You had to prove some extra level of risk, like being stalked or facing a specific threat. If your reason didn't meet the state's narrow standard, your application was denied. In June 2022, the Supreme Court ruled 6-3 that this law violated the 2nd and 14th Amendments of the U.S. Constitution. Writing for the majority, Justice Clarence Thomas made it clear, if a law limits your Second Amendment rights, it must be consistent with the Constitution's text, history, and tradition. In plain English, modern gun laws must be rooted in historical precedent, not based on what current lawmakers think is reasonable or necessary. This ruling set a new legal standard and sent a clear message. You don't need to prove danger to exercise a constitutional right. Following the Supreme Court's 6-3 ruling, many anti-gun politicians haven't backed down. They've doubled down. We're seeing what experts call soft resistance. States can't outright deny your right to carry anymore, but they can still bury you in red tape. New laws are being drafted to limit carry locations, raise renewal fees, and impose arbitrary suitability checks that make it harder to qualify, especially in urban areas. In California, lawmakers are pushing legislation that redefines sensitive places so broadly that almost any public space could be off-limits to carry, even with a permit. In New Jersey and Massachusetts, legal teams are crafting new bills that appear compliant on the surface but are designed to sidestep the ruling's intent. Make no mistake, this isn't just resistance. It's retaliation. While the Supreme Court has set the standard, gun owners must be prepared for an aggressive second round in the courts and at the ballot box. This ruling didn't just affect New York. It sent ripple effects across the entire country. States like New Jersey, California, Hawaii, and Maryland had similar laws that required citizens to justify why they needed to carry a firearm. These states used a may-issue model where approval was subjective and often denied without a clear reason. After the Supreme Court's decision, many of these states are being pushed toward a shall-issue system. That means if you meet the basic legal requirements, such as passing a background check and completing training, you must be approved. There's no longer room for personal judgment from local authorities. However, some states are responding with resistance. Instead of eliminating restrictions, they're building new legal frameworks that create more obstacles. These include extended waiting periods, more expensive and time-consuming training, and strict rules on where you can legally carry. In response to the ruling, New York passed a revised law that designates a long list of sensitive locations. These include Times Square, public transportation, parks, bars, libraries, and houses of worship. Critics argue the list is so broad that it makes legal concealed carry nearly impossible, even for permit holders. When this new law was challenged, the Supreme Court chose not to intervene at this time. As a result, the debate continues in lower courts, where legal challenges are actively underway. One thing is certain, the ruling may have set the stage, but the fight is far from over. The most important part of the Supreme Court's decision is the new legal standard it created. From this point forward, courts reviewing gun laws must ask a very specific question. Does the regulation align with the Constitution's original text, and does it reflect the history and tradition of firearms regulation in early America? This means judges can no longer rely on modern ideas about public safety or current policy preferences. Instead, they must look to how guns were regulated during the 1700s and 1800s. If a law restricts things like magazine capacity, bans certain types of firearms, or limits where people can carry, it must be backed by clear historical examples from that period. That's a very high bar to clear, and it's already having a real impact. Several federal courts have struck down modern gun laws, including magazine limits and transportation restrictions, because they couldn't find any equivalent laws from the founding era. This new test, text, history, and tradition, is reshaping how the Second Amendment is applied across the country. For most gun owners living in states with strong Second Amendment protections, places like Arizona, Tennessee, or Texas, this ruling won't change much. These states already offer straightforward permit systems or allow permitless carry altogether. But for those in more restrictive states, this decision is a game changer. You no longer have to prove why you deserve to carry a firearm. If you meet the basic legal requirements, that's enough. This restores access for thousands of people who were previously denied permits under vague and subjective standards. However, not every state is giving up quietly. In response to the ruling, some are creating new roadblocks. These include more paperwork, higher permit fees, and longer wait times. Others are introducing expanded background checks, character references, or extra training requirements to slow the process down. While these changes are being challenged in court, they show that the fight over carry rights is far from settled. The Supreme Court has spoken, but states are still finding ways to push back. For everyday gun owners, this means knowing your rights, staying informed, and being prepared to act when your freedom is tested. This case isn't the end. It's the beginning of a new chapter in Second Amendment law. Thanks to the Supreme Court ruling, courts across the country are now being forced to re-examine a wide range of gun regulations at both the state and federal levels. That includes laws like magazine capacity limits, such as the 10-round restrictions in California and New Jersey, bans on rifles based on cosmetic features, often labeled as assault weapon bans, mandatory waiting period, even when someone has already passed a background check, and storage and transportation rules, including strict locking requirements or restrictions on carrying firearms in personal vehicles. We're already seeing results. In California, a federal court has struck down the state's magazine capacity law, declaring it unconstitutional under the new legal test based on text, history, and tradition. And that's just the beginning. Similar lawsuits are underway in states like Illinois, Maryland, Massachusetts, and Oregon. As these cases move through the legal system, appellate courts and eventually the Supreme Court will decide how far this new framework really goes. What comes next depends on whether the courts follow the precedent that has now been firmly established. But make no mistake, this wasn't just one ruling. It was a spark. And now a chain reaction has begun, one that could redefine gun rights in America for a generation. Let's be clear, this isn't the finish line. The opposition isn't going away. States that want stricter gun laws are already working on new legislation that appears to follow the Supreme Court's ruling, but still makes it harder for law-abiding citizens to carry or own a firearm. And the media will continue to spin every court case, every headline, and every ruling to create fear, confusion, or doubt. That's why, now more than ever, it's critical to stay informed. Being a responsible gun owner today means more than just knowing how to handle a firearm. It means knowing the laws. It means understanding your rights, and it means standing with the community that's working to protect those rights for the next generation. We need to keep supporting the organizations doing the legal heavy lifting, groups like Gun Owners of America, the Firearms Policy Coalition, and the Second Amendment Foundation. These are the organizations that challenge unconstitutional laws in court and win. But it doesn't stop there. Share real information. Talk to your friends and family. Help others understand what's happening. Because when we stay informed and engaged, we do more than defend our rights. We make them stronger for everyone. Your voice matters and the work continues.